Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Pratt is still in shock or in doubt about the ruling of the Supreme Court against the decisions of the Speaker of Parliament, which I want you to join me today listening to what he said about the Supreme Court ruling. But before you go, I would like you to subscribe to the channel, hit the notification bell, turn it to all so that you'll be the first to receive or be notified on whatever we upload onto the channel. This station still remains the best and still PENDREAM TV, your only authentic source of political news. Don't forget to subscribe to the channel, turn the notification bell on so that you not miss a lot. Thank you.
I'll come to Comic Price shortly. But before I do that, just a couple of your comments that you're sharing with us. This Edward Dubazao says, Article 97(1)(g)(h) states, the MPs must vacate their seats in Parliament immediately they stop doing business with the party that sent them to Parliament. Then it continues, the Speaker is not, the Speaker is not supposed to say anything. Samuel Evans Otta says, even the South people who complained didn't get a hearing. But the MPP women, but the Supreme Court is seeking a hearing for the people that are not complaining. Patron Solo says, are you saying that because the Supreme Court is a small God, everything they say must be obeyed, even in the full glare of the citizens that they are wrong? Come on, they should not. Okay, thank you very much. That is some more of the messages that you're sending to us. Teacher Shamsu says, Senator, who will advise the Justice of the Supreme Court and Chief Justice to distance themselves from the politicking? Senator, how on earth will these justices always think the same anytime a case relating to NDC pops up? It is about time the MPP realize that this country is not theirs and that they can't always have their way anytime an issue of this nature surfaces. Well, we in the NDC are currently waiting for 7 December so we elect JM to turn around the misfortunes machinated by this MPP government into great fortunes for the generations yet unborn. Mensa Sister says, my question, can a new government do something with the this question keeps coming up with the current Supreme Court and the Judiciary when the NDC comes to government from 2025. And Abdul Ghaffar Mohammed says, can any institution have a law that is not in line with the Constitution of Ghana? Come in.
Well, to start with, I've made extensive comments on the Supreme Court decision. And it is not my intention this morning to repeat all the comments that I've made before. What I'd like to emphasize that it is only in Cuckoo's Land that the assumption can be made that a Supreme Court decision necessarily stops all disputes. It doesn't. As we speak here, as we sit here, the conflict in Boku is raging. And the conflict in Boku is raging in spite of numerous Supreme Court decisions. So Boku should tell us very clearly that the assumption that the Supreme Court is the final arbiter in legal disputes and so on cannot be understood that once the Supreme Court makes a decision, disputes vanish, conflicts vanish, and so on. It's not true. Boku is the clearest example. Now, the second point that I like to make, and this point has been made by several people, it's not my original thought, is simply that decisions of the Supreme Court have to have a certain level of consistency. Because if they fail to have a certain level of consistency, what it would then mean to ordinary mortals like me and so on, that every judge and any judge can decide anything, and that the law itself has no consistency. In which case, the interpretation of the law will be seen as a biased enterprise. And once you begin to see that the interpretation of the law is a biased enterprise, and is not rooted in principle and so on, we create conditions for general anarchy in our society. Now, why do I say this? I say this because that day when I listened to the Supreme Court judges, those who were empaneled, when I listened to them, one of the reasons they stated was that the Supreme Court has jurisdiction, appellate jurisdiction, in all judicial decisions. And Senna, I was so shocked. Because the Supreme Court of Ghana has in an earlier case decided that when it comes to election disputes, the Supreme Court does not have appellate jurisdiction. The Supreme Court had told us that if you look at the relevant sections of the Constitution, articles in the Constitution, which deals with, election disputes are to be heard by the High Court. And that the Constitution expressly says that if parties in the dispute are not satisfied, they may appeal to the Court of Appeal. And that because the Supreme Court is not expressly stated in the Constitution, the Supreme Court has no jurisdiction when it comes to election disputes. So at least in one instance, the Supreme Court has told us that its jurisdiction is not over all matters or all decisions that are taken by the judiciary or arms of the judiciary and so on. So how come that the Supreme Court is taking this decision? And the shock of it is that it's a unanimous decision. Okay? The shock of it all is that it's a unanimous decision. So the question that I'm asking is that if the same panel which had heard the previous case had heard this case, what would the verdict have been? And if the verdict would have been different, what is the message we are sending to the Ghanaian people? That the decision of the court depends on who are members of the panel. That's a bit worrisome, okay? And many people have made this point, including lawyers of repute and so on. They've made this point and they've made it very, very strongly. Now, the other thing that I find extremely strange is the demeanor of some of the judges. And the judges themselves will tell you that demeanor is important. When they are trying cases, one of the things they take into account is the demeanor of witnesses who appear before them, the demeanor of parties to the dispute, and the demeanor of accused persons and so on. Is an important consideration in law. So I'm not making it up. Now, if you look at the demeanor of some of the panel members, it is worrying. And indeed, I read one newspaper which made the point about the anger displayed by the Chief Justice. I'm saying that Chief Justice, judge of the Supreme Court, a matter of constitutional interpretation has been placed before you. Where does the anger come from? How can you be angry? Indeed, you are not expected to display anger, which is an emotion. You understand? So that anger itself raises many substantial questions. And it was displayed, in ways which I felt, as a citizen of this country, were unpalatable. You understand? For example, I heard the Chief Justice say, in a demeanor which can only be seen as anger, that how come, where is this country going to, and so on. How come that in the midst of all that is happening, Parliament is not sitting? There was nothing before the court, nothing before the court about whether Parliament should sit or not sit. The issue before the court was not about Parliament sitting or not sitting. You understand? And yet, she made this comment in open court, and I think that that comment, judicial notice can be taken of that comment. Then there was a point also where she actually went into exchanges about why the speaker had not filed, or the lawyers of the speaker had not filed their responses, you know, to the case which had been filed by the plaintiffs. And I'm a layman. I didn't go to law school. I'm sitting at home. And I'm saying that, look, what am I missing? The lawyers of the speaker had gone to court to ask the Supreme Court to set aside decisions that it had made earlier because the processes were legally invalid. That's the case they took to the Supreme Court. Now that carries an assumption that as far as they were concerned, there was nothing illegal and substantive before the Supreme Court. How can they answer? Master, how can they answer when they think that properly speaking, legally speaking, constitutionally speaking, there was nothing valid before the court? So their case before the court to set aside the decisions of the court is a response. It is only after that has been dealt with that they may or may not file, you know, responses to the original case before the Supreme Court. So I was really surprised. And then instantly, the Chief Justice poses a question to the lead counsel for the Speaker and says, can we go ahead without you? Now, this is the same court which had insisted that anybody whose case is being heard needs to be given a hearing. Being given a hearing was so important for this panel. And yet, at the same time, when it came to the Speaker, they wanted to know whether they could go ahead without the Speaker. In fact, they pressed upon the Speaker's lawyers that they could vacate their rights to make an appearance, to participate in the decision. And I found that exceedingly strange. Now, Senna, I think that there are some principles which ought to be made very, very clear to all public servants, including those who sit on the bench. Okay? Why do we have a Supreme Court? Why do we have Supreme Court judges? One, we have a Supreme Court and its judges only because all the 32 million people of Ghana cannot sit in judgment in cases. Okay? So our power, our right to judge, to interpret the Constitution and so on, is delegated to some people to act on our behalf. I hope you understand what I'm saying. So anytime the Supreme Court sits and makes a decision, it is making that decision in our name, in the name of the people of Ghana. Anytime the Supreme Court makes a decision, that decision rightly is made in the name of the people of Ghana. Okay? Now, the Supreme Court itself is a creation of the 1992 Constitution. Okay. Now, this 1992 Constitution did not fall from heaven like the tablet on which Moses' 10 commandments were found. it was political struggles, political negotiations, and so on, which led to the crafting of the 1992 Constitution. And in the process of fighting for change, fighting for a return to limited democracy, what others will refer to as bourgeois democracy, people died. People lost their lives in that struggle. People suffered imprisonment. Many, many sacrifices were made in order to craft that constitution. So at every stage, we, including the Supreme Court judges, should be asking ourselves whether or not decisions which are being made today are in tune with all those who sacrifice so much, and so on, their aspirations. Is this what they were expecting? You understand? Is this outcomes for which they laid down their lives? Are these the outcomes for which people suffered so much in order to craft the 1992 Constitution? Now, the Supreme Court has made its decision, okay. And I think that it is possible for us to look at the practical outcomes. Possible outcomes. I've seen a letter written by a young man to the Speaker of Parliament, in which this young man is actually warning the Speaker of Parliament that if he doesn't accept the decisions of the Supreme Court, it would amount to a high crime for which he can be impeached, and so on, obviously. Now, I'm sitting at home reading this letter, and I'm wondering, indeed, Parliament would make its decision. It is possible for the Speaker to convene Parliament on the 7th of November and announce the decision of the court, and to tell Parliament that this is the decision of the court. What do? Parliament can take a decision on it. Okay. Now, if Parliament doesn't have a quorum, that decision would not be taken. Parliament needs a quorum in order to be able to take that decision. And if Parliament does not have a quorum and can therefore not take that decision, it means that Parliament would not continue to sit. So the Supreme Court decision would actually not be implemented. Not because the Speaker wants it or does not want it, but simply because the House would not have the quorum for making decisions. That's number one. Let us say that the Speaker goes to Parliament and says that I make those orders, I'm withdrawing those orders. That's another possibility. And therefore, the MPP group, not caucus, the MPP group in Parliament, and I'll explain that, the MPP group, not caucus, is the majority. If the Speaker were to make that declaration in Parliament, and the NDC side decides to walk out, will Parliament be able to sit? What will be the effect of the decision of the Supreme Court when the NDC group decides to walk out, to protest, and so on? And the NDC group has a right of protest, the right to protest. If they decide to protest in that matter, that decision of the Supreme Court would mean nothing, would have no effect, and so on. Okay. Now, let us also assume that the Speaker decides to defer the Supreme Court. How is the Supreme Court going to enforce its decision? Is the Supreme Court going to order the police to arrest the Speaker? Is the Speaker going to be arrested? Is the Speaker going to be imprisoned? And what will be the consequences of that for the work in Parliament and for the practice of this limited so-called bourgeois democracy in our country, if such an order were to issue. And in any case, if such an order were to issue, will the security forces, perhaps the police, effect that order? So what will be the consequences for all of us? Now, let us say that the Supreme Court then decides to charge the Speaker with contempt for not respecting his decisions or for obstructing his work. Now, if you read the Constitution very, very carefully, Parliament itself can also hold all citizens, including panel members of the Supreme Court, in contempt. So what if the Speaker also cites the panel members for contempt? What then happens? I hope you are getting the picture. What then happens? What crisis would we have created? And what are the options for getting out of this crisis? Now, the point ought to be made that Parliament as an institution is a place for debate. It's a place for reaching compromises. It's a place for negotiations and so on. You understand? That is the nature of Parliament. Now, have we come to the point where Parliament as a forum for debate and negotiations no longer exists? Have we come to that point? Have we come to that point where Parliament as a place for negotiations no longer exists? And so on. And if we come to that point, what is the value of this democracy and so on? You know, these are concrete questions which I think that all of us, you know, need to answer. Okay. Now, I've made this point also about minority caucus and majority caucus and so on. And interestingly, the Supreme Court itself made reference to a minority caucus and a majority caucus. And I found it extremely strange. Now, because what happened in Parliament after the 2020 elections is that we had a hung Parliament. A Parliament in which there was no majority and there was no minority. MPP had 137 members of Parliament, and NDC had 137 members of Parliament, with one independent candidate. So the MPP caucus could not be the majority, and the NDC caucus could not be the majority. So some decisions had to be made. Now, strangely, and I say strangely because I disagreed with the Speaker's ruling, okay, the Speaker came to the conclusion that instead of having caucuses of parties, they should have groups. And the Speaker decided that the independent member of Parliament could join the MPP MPs in order to form the majority group, not caucus. Now, why did the Speaker do that? The Speaker did that because of the very, very provisions of the Constitution that we are talking about, which prevent crossing carpet. Because if the independent member of Parliament had joined the MPP caucus, he could have been, according to the Speaker, he could have been deemed to have crossed carpet and therefore should have lost his seat for by-elections to be conducted in his constituency. So the Speaker, in his wisdom, then decided that he joins the MPP group and not the MPP caucus. And that makes the MPP group the majority group and not majority caucus. Now, I have a fundamental disagreement with the way Parliament approached the issue, especially the Speaker. And that is simply the fact that we have always operated on the assumption that there will always be a majority and there will always be a minority. And because of that, the standing orders of Parliament, which are the rules governing the conduct of business in the House, has been crafted on the basis of majority versus minority. Now, when we got into a situation where we saw that it was no longer to operate on the old tradition and so on, we should have been able to craft a new standing orders which takes account of a hung parliament where there's no majority and minority. Now, instead of doing that, we took the easy route and now created groups instead of caucuses and allowed this independent candidate for all practical purposes to cross carpet to the MPP. And that's my problem. Okay? So if you take the results of the parliamentary elections of 2020, there's no majority and there's no minority. This majority and minority was a creation of the speaker based on his own ingenuity and so on. He created this. Now, if you look at Article 97, G and H, as far as I'm concerned, the meaning is clear. The meaning is clear. But then there are others who argue that, yeah, the meaning may be clear to you, but it may not be clear to us. And for as long as there is some dispute about its interpretation, then we have to go to the final arbiter when it comes to interpretation of the Constitution, which is the Supreme Court. Fair enough. Let us just apply logic. Just plain logic, not difficult logic. I mean, the logic which sometimes is referred to as common sense. That's all. Let's take the case of Honorable Cynthia Morrison. That's the case of Honorable Cynthia Morrison. Honorable Cynthia Morrison was elected not as an independent candidate. She was elected, her constituents elected her to go to Parliament as an MPP parliamentarian, to join the MPP caucus and to use the floor of Parliament to ensure that the manifesto of the MPP, the agenda of the MPP and so on, can be implemented. That's how she was elected. You understand what I'm saying? Now, Honorable Cynthia Morrison has decided, it is not a rumor, notice of polls have already been filed. She has decided that she's no longer able to represent the New Patriotic Party. She's not able to represent the New Patriotic Party. So, the people who elected her to go into Parliament to represent the New Patriotic Party and so on, her current position and the position of the electorate who sent her to Parliament are in conflict. Who can argue against this? They are clearly in conflict. Now, the MPP itself, by its own constitution, has said that Cynthia Morrison can no longer represent them, because a provision in the MPP constitution says that anytime you stand against an MPP candidate, you automatically lose your membership. So you have Cynthia Morrison in Parliament. MPP says that you can no longer represent us. She herself says that I have no interest in representing you and so on. And yet the Supreme Court says that she must represent the MPP. What is this? Very strange. Exceedingly strange. But then the court also decides that it is taking this decision because if her seat is declared vacant, her people will have no representation in Parliament. And then I go back to the de-escalation case. You remember? Where his seat was actually declared vacant. Now, when Jesse Kwese's seat was declared vacant, how were the people in Asin South, is it? Asin North,
yeah.
represented in Parliament when his seat was declared vacant? But maybe you can argue, put forward all kinds of arguments and so on. What about the people of SAR, who for 4 years have had no representation in Parliament? And it is not as if the Supreme Court is not aware of the fact that the people of SAR have no representation. For 4 years, no decision has been taken which enables the people of SAR to have representation in Parliament. So that's weird. That's strange, you understand? Now, all of these things, and in fact the NPP doesn't hide it, all of this legal maneuvering and so on, and in fact the Chief Justice alludes to it, has to do with granting tax waivers. You know, granting tax waivers to some companies, that if the NPP doesn't have majority, its intention of granting tax waivers to some companies may not be realized. And the first question I ask is that, so all these tax waivers we've been granting in the last 7 years, what has been its effect? What has been its impact on the economy? Granting tax waivers, are they so very important as to push us into this completely unnecessary crisis, tax waivers? Has anybody taken the trouble to do a study about the impact of tax waivers on the economy? And why all of us should be dragged into this needless controversy and so on over the ability to grant tax waivers and so on? I don't know. So now the other issue which has been raised is simply the fact that next year, 2025, there ought to be a budget. And that budget ought to come before Parliament for approval. I don't know where that is coming from. The practice has always been that because of the possibility of getting a new government next year, there will be no budget before the elections. You understand what I'm saying? That there will be no budget before the elections. And that after the elections, the new government will then have the opportunity of presenting its budget. And that what has to be done is some interim financial arrangements which enables the new government to function until such time that it can present a new budget. So that argument about government being put in jeopardy because it cannot present a budget and so on, where is it coming from? Where is it coming from? Now, I find this controversy also to be particularly needless. Particularly needless. Because for every bill or everything that will be presented to Parliament for a decision, that decision will be made simply by votes. And whether or not we are the majority group or majority caucus or minority group or minority caucus is inconsequential. Because it will be done by votes. Now, if you look at the current composition of Parliament, I am quite sure that voting in Parliament would not be along the lines of 137 for NDC and 137 for NPP. Never. How can that be? It won't. So whether the NPP group is declared as majority group or minority group, its ability to marshal the numbers in order to take decisions that are favorable to government and so on is already in jeopardy because of the internal politics in that party. So, to some extent, if you sit back and you watch this rigmarole, about minority group or majority group and so on, it sounds ridiculous. Now, let's say that 7 December arrives. Thank you, sir. 7 November arrives, and Parliament is recalled. The Speaker has to be the last person to enter the chamber. As the Speaker enters the chamber, both NDC and NPP are struggling for the right side of the Speaker. Because by that time, the decision will not have been made. Okay? The decision to accept the Supreme Court verdict or not will not have been made. So there will still be the contention. What happens? Some have even suggested that it could lead to scuffles and so on. How is the Speaker able to take control of this situation and accept the Supreme Court decision or not accept the Supreme Court decision? I want to submit that the way out of this apparent crisis is not a Supreme Court decision. The way out of this apparent crisis is a very, very high-level display of statesmanship. Very, very high display of statesmanship. The exercise of simple gumption. The way out of this problem presents a test to the negotiating ability of the ruling elite in Ghana. So that's the point now. Okay. Early this week, I did an interview with a retired appeals court judge. And he said, on mic, that he really misses Che Mensah Bonsu. That if Che Mensah Bonsu was still the majority leader, we would not have come to this. And I've heard many, many others say that they miss Che Mensah Bonsu. Because he was adept at negotiation and so on. You understand? He did not push for confrontation where confrontation was avoidable and so on. Perhaps we should all agree with this retired judge of the courts of appeal. I don't want to think that all of this maneuvering is about positioning for the 2024 elections. I don't want to. You understand? But Senna, I'm already beginning to see some signs around the 2024 elections which are extremely worrying. And I hope that this is not one of them. I mean, I was shocked to the marrow when I heard the U.S. Embassy make a statement that those who don't play the game by the rules and so on will be refused visas to the United States of America. What nonsense. The United States of America is not heaven. So if people don't go to the United States of America, so what? The U.S. has no authority to decide the legitimacy of what we do as Ghanaians, how we hold our elections. So the U.S. has no role to play in it. Those decisions must be made by the Ghanaian people. Because we do know that wherever the U.S. has made such interventions, it has only led to chaos. Look at Venezuela. Look at how the people of Venezuela are suffering because of this needless intervention by the United States of America. Sometimes it's not even about elections. It's about political choices which are not necessarily about elections. Look at Cuba. Look at what they've done to Cuba. 2 million people have died in Iraq. We are not expecting the United States of America to decide for us what processes we follow or we do not follow. The U.S. has no business and they should stay out of this. The people of Ghana have the capacity to decide for themselves whether elections have been rigged or not. And when elections are rigged, the people of Ghana who fought and defeated classical colonialism, who have changed governments many times and so on, will do it again. Why? The US believes in democracy. It is the belief of the US in democracy which led it to sponsor the 1966 coup against Kwame Nkrumah. Is that what we are being told? And indeed, all the problems we have today can be traced, or most of the problems can be traced to the 1966 coup. The US. The US, which was involved in the assassination of Patrice Lumumba because of his political views and so on. It has no role to play in Ghana, no role to play in Africa. They should shut up and leave us alone.
Thank you. Thank you very much. Well, we're still expecting Courage Nobi to join us, and also Honorable Francis Xavier Sosus to join us. We'll take a break. When we come back, I'll go through some of the comments you're sending on this issue, many comments that you're sending. I'll go through some of them, and if we do have them in the studio, we'll take their views. If not, we'll move on to next topic of discussion. This is the Mother of All Talks with Alaji and Alaji. Stay with us.
No freedom, he's the Redeemer. He has labored, he has suffered to lead his people into the land of freedom. He is the Redeemer.
The filing of an application to set aside the rates on that basis. Indeed, the grounds for such a contention will have to be in a statement of case filed at the point raised for determination by the court. And the court will notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General file issues for determination in this matter, and those are issues raised in the for determination by the court. Respectfully, indeed, the application completely misunderstands and misconceives the Supreme Court's original jurisdiction. And I made the point that, indeed, the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen. My lady, the first defendant makes reference to an alleged denial of the right to a hearing on the authorized pattern by the filing of a motion ex parte. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court retaining an application for application ex parte. If indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court.
PENDREAM TV now so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.